recognized. We can go. Senator Kyl.
Thank you. Mr. General Kagan, you can see how important my colleagues think my questions are here.
I'm here.
Or how important my answers are.
Well, when we met, I tried to give you an idea of the questions that I would ask, and I think I can pretty much follow what I laid out to you, so let me do that. I also think most of my questions can be answered pretty succinctly, and I would appreciate if you could do that. So let me start by asking you the standard for judges in approaching cases that we talked about, starting with the President's idea. I'll remind you, he's used a couple of different analogies. One was to a 26-mile marathon and said that in hard cases, adherence to precedent and rules of construction and interpretation will only get you through the first 25 miles. And he has said that while the law is sufficient to decide 95% of cases, in the last 5%, legal process alone will not lead you to the rule of decision. He says the critical ingredient of those cases is supplied by what is in the judge's heart, or the depth and breadth of a judge's empathy. My first question is, do you agree with him that the law only takes you the first 25 miles of the marathon and that the last mile has to be decided by what's in the judge's heart?
Senator Kyl, I think it's law all the way down. It's when a case comes before the court, parties come before the court, the question is not, do you like this party or do you like that party? Do you favor this cause or do you favor that cause? The question is, and this is true of constitutional law, it's true of statutory law, the question is what the law requires. Now, there are cases in which it is difficult to determine what the law requires. Judging is not a robotic or automatic enterprise, especially on the cases that get to the Supreme Court. A lot of them are very difficult, and people can disagree about how the constitutional text or precedent, how they apply to a case. But it's law all the way down, regardless.
In the time of sentencing, a trial court might be able to invoke some empathy, but I can't think of any other situation where, at least off the top of my head, it would be appropriate. Can you?
Senator Kyl, I don't know what was in the, I don't want to speak for the President. I don't know what the President was speaking about specifically. I do think that in approaching any case, a judge is required, really, not only permitted, but required to think very hard about what each party is saying, to try to see that case from each party's eyes, in some sense to think about the case in the best light for each party, and then to weigh those against each other. So I think that the judge is required to give consideration to each party to try to figure out what the case looks like from that party's point of view. And that's an important thing for a judge to do. But at the end of the day, what the judge does is to apply the law. And as I said, it might be hard sometimes to figure out what the law requires in any given case, but it's law all the way down.
Statutory, Constitution, the law, precedent.
That's correct.
Now, when the President announced the retirement of Justice Stevens, he said judges, this is a slightly different formulation, so the next question has to do with the second way that he formulated. He said judges should have a keen understanding of how the law affects the daily lives of the American people and know that in a democracy, powerful interests must not be allowed to drown out the voices of ordinary citizens, was the way he put it. Now, the media outlets have summarize this and call it the fight for the little guy sensibility. I'm not sure that's exactly the way the President would put it, but you heard some of my colleagues here yesterday lament the alleged activism of the current court in supposedly always ruling for the corporate interests or the interests of big business. Do you agree with the President and my colleagues that judges should take into account whether a particular party is a big guy or a little guy when approaching a question of law, or that one side is powerful, or that one side is a corporation?
Well, here's what I think. I think that courts have to be level playing fields, and that everybody has to have an opportunity to go before the court, to state his case, and to get equal justice. And one of the glorious things about courts is that they do provide that level playing field in all circumstances, in all cases. And even when that level playing field is not provided by other branches of government, even when there's some imbalance with respect to how parties come to Congress or the president or the state houses, that the obligation of courts is to provide that level playing field, to make sure that every single person gets the opportunity to come before the court, gets the opportunity to make his best case, and gets a fair shake. As
Now,
I think I said
may I
yesterday.
just interrupt? When you say level, to ensure a level playing field, you're not saying that if the parties come to court with positions that are unequal, that is to say one party's position is better than the other party's position, that the court's obligation is to try to somehow make those two positions the same.
No, no, no.
And
I mean, it's just a matter of everybody is entitled to have his claim heard. Everybody is entitled to fair consideration. And it doesn't matter whether you're an individual or you're a corporation or you're the government. I mean, one of the really remarkable things about watching actually a Supreme Court argument is sometimes I go up there and I'm arguing for the government. Very sort of, I mean, you would think it's kind of a favored position to be arguing for the government. And it turns out it's not. It turns out that the justices give you, as the government's representative, just as hard a time, maybe a harder time, than they give anybody else. And that's the way it should be. That whether you're the government, whether you're a corporation, whether you're a person, no matter what kind of person you are, no matter what your wealth, no matter what your power, that you get equal treatment from the court. And what I meant by equal treatment is just that the court takes your claim seriously, takes your case seriously, listens to you as hard as it listens to anybody else, and then makes the right decision on the law.
during his confirmation hearing, Chief Justice Roberts said, if the Constitution says, this was in response to a question, by the way, and he said, if the Constitution says that the little guy should win, the little guy is going to win in court before me. But if the Constitution says that the big guy should win, well, then the big guy is going to win because my obligation is to the Constitution. That's the oath. Do you agree with Chief Justice Roberts?
I do, Senator Kyl.
Now, one of the things that I brought up in my opening statement was obviously your clerkship for Justice Marshall, and my belief that Justice Marshall's views are more along the line of viewpoint that President Obama expressed. And you wrote about this on in more than one way. Let me just cite one thing you wrote about Justice Marshall's view, and I'm quoting now. You said, in Justice Marshall's view, constitutional interpretation demanded, above all else, that the courts show a special solicitude for the despised and disadvantaged. It was the role of the courts in interpreting the Constitution to protect the people who went unprotected by every other organ of government, to safeguard the interests of people who had no other champion. The court existed primarily to fulfill this mission, you wrote about Justice Marshall. And in fact, you also wrote that if he had his way, cases involving the disadvantaged would have been the only cases the Supreme Court heard. What's unclear to me is whether you agree with Justice Marshall's view of the role of the court in constitutional interpretation.
Senator Kyl, the last statement you read, the statement about it would be the only case, I think that was a kind of jokey statement, so I would put that aside.
Okay.
I think what I was saying in that piece is consistent with what I've said to you. I think Justice Marshall's whole life, and this is why I said he revered the Supreme Court, Justice Marshall's whole life was about seeing the courts take seriously claims that were not taken seriously anyplace else. So in his struggle for racial justice, you know, he could go to the state houses or he could go to Congress or the president, and those claims generally were ignored.
Well, let me just interrupt for a second. You wrote here that in constitutional interpretation, so this is not just a factual matter between two parties, we're talking about interpreting the Constitution. He says the courts should show a special solicitude
Well, I think that was my words, and I meant,
Yes,
I
correct.
meant special as compared with the other branches of government. In other words, that it was the court's role to make sure that even when people have no place else to go, that they can come to the courts and the courts will hear their claims fairly. And that was what I was saying was a wonderful thing about courts, a miraculous thing about courts, that you can be ignored in every other part of the government. And you can come to a court, and a court will say, it's our job to treat you with respect, with consideration, with the same kind of attention we give to everybody else.
Well, let me just ask you, do you believe then, and it's hard, I realize, though you certainly know, you knew Justice Marshall very well, you knew his reasoning, that he would have agreed with Justice Roberts that if the big guy has the law on his side, the big guy wins. If the little guy does, then the little guy wins, and that's consistent with what Justice Marshall believed. Or would he have expressed it more along the lines that some of my colleagues have here, that there's too much agreement with the corporate interests and big business, as one of my colleagues put it?
Senator Kyl, I guess 2 points. The first is, I guess I don't want to spend a whole lot of time trying to figure out exactly what Justice Marshall would have said with respect to any question, because the most important thing, I love Justice Marshall. He did an enormous amount for me. But if you confirm me to this position, you'll get Justice Kagan. You won't get Justice Marshall.
Well,
and that's an important thing.
Yes, and I totally agree with you. It's not what Justice Marshall believed that's important here. It's what you believe. But since you have written so glowingly about him, you called it, in fact, his vision of the court, a thing of glory, I believe. I'm having a hard time figuring out whether, to the extent that you do, and you have written glowingly about him, whether you would tend to judging cases more actively or more with interest in protecting the rights of those who are disadvantaged, for example, or, as you have already expressed here, you would simply base it on the facts and the law and the Constitution.
The thing of glory, Senator Kyl, is that the courts are open to all people and will listen respectfully and with attention to all claims. And at that point, the decision is what the law requires. And there may be differences as to what the law does require, but it's what the law requires, and that's what matters. I guess I would like to go back to I'll just give you one case just to make sure that.
Well, could I just keep moving on? I know the time. Well, we don't have a lot of time. If I could, please. Do you agree with the characterization by some of my colleagues that the current court is too activist in supporting the position of corporations and big business?
Senator Kyl, I would not want to characterize the current court in any way. I hope one day to join it.
And they said you're not political, right? I appreciate it. Let me explore your judicial philosophy just a little bit more here. Whether you agree with the comment that Justice Marshall said, he said you do what you think is right and then let the law catch up. Do you agree that that's the right way to approach judging?
The way I would judge is the way I told you, that you make sure that you give very respectful consideration to every person and then determine what you think the Constitution or a statute, if the case is a statutory case, requires.
So you wouldn't have phrased your philosophy as Justice Marshall phrased his? You know,
I actually never heard Justice Marshall say that. I know another clerk in a different year wrote that she did. I will say Justice Marshall was a man who spent many decades of his life fighting for the eradication of Jim Crow segregation. And you can kind of see why he thought that you should work as hard as you can.
He worked outside the box.
Eventually the law will catch up.
Yeah.
And eventually the law did catch up in Brown versus Board of Education.
That's right. That's why it didn't seem to me to be out of character for him to have said that. Is there anything that you've written? Obviously you haven't rendered decisions which would enable us to verify that this is your approach to judging. Can you think of anything you've written, or if you'd like to just supply this for the record, if it doesn't come to you immediately, that would verify what you have said for us here, that would help us to confirm that what you've expressed to us today is in fact a view that you've expressed about judging.
Well, I don't think I've written anything about judging in that way, but I think that you can look to my life, that you can look to the way I interact with people. I mean, my deanship was a good example, but the way I've acted as Solicitor General as well, the kind of consideration that I've given to different arguments, the kind of fairness that I've shown in making decisions, I think that those would all be, appropriate things to look to try to get some understanding of this aspect of me.
Okay. Let me ask you about some of the bench memos. I talked to you a little bit about that when you were in my office as well, and obviously we only have time to mention a few, but what I was suggesting is that your advice to your boss seemed to be not just pragmatic, but almost political in advising him either to vote to take a case or not to take a case on cert. For example, in Lanzaro versus Monmouth County, you wrote, and I quote, "Quite honestly, I think that although all of the lower court's decisions is well intended, parts of it are ludicrous. But you discouraged Justice Marshall from voting to review the decision because you were afraid that the court," and I'm quoting now, "might create some very bad law on abortion and or prisoners' rights." Now, when deciding whether or not to take a case, shouldn't the focus be on whether the appellant or the appellee has the facts and the law on their side rather than worrying about whether justices might, in your view, make bad law?
Senator Kyl, let me step back just a little bit and talk about what clerks did for Justice Marshall. We wrote, Justice Marshall was not in what's called the cert pool. We wrote probably thousands of memos over the course of a year about what cases the court should take and what cases the court should not take. And when I was clerking for Justice Marshall, I was 27 years old, and Justice Marshall was an 80-year-old icon, a lion of the law. He had firm views, he had strong views, he knew what he thought about a great many legal questions. He had been a judge for some fair amount of time. And the role of the clerks was pretty much to channel Justice Marshall, to try to figure out whether Justice Marshall would want to take a case, whether Justice Marshall would think that the case was an appropriate one for the court to take and to decide. And that's what I did, and I think that that's what my co-clerks did as well.
Well, do you think you would approach cert decisions that way if you were on the court?
I think that the most important factors in the cert decision process, which is I think one that I talked to Senator Cole about maybe, are the ones I gave. First, most importantly, are the question of circuit conflicts, that the court, it's a very important responsibility of the courts to make sure that our law is uniform and to resolve any conflicts that appear among the circuit courts. Second is the court should be available almost all the time where a judicial decision invalidates a congressional statute, that Congress is entitled to that kind of respect, to have the Supreme Court hear the case before a congressional statute is invalidated. Third, for some set of extremely important national interests, extremely important for any number of reasons. It's a small category of cases, but it's an important one. And I think that those would be the considerations that I would primarily use, and that is the way I would make decisions. All right.
There are some of these bench memos suggest other bases for making decisions. For example, in Cooper versus Kotarski, in assessing whether the court should take the case, you wrote, quote, "It's even possible that the good guys might win on this issue." Now, that wouldn't be a very good basis on which to suggest taking a case, would it? Who are the good guys?
As I took a look at that memo, Senator Kyl, that was just a reference to the people whom I thought Justice Marshall would favor on the law, and that's all the reference was meant to suggest. Just the people whom I thought Justice Marshall would think had the better of the legal arguments.
Well, the reason I cited that one is there's a note while you were at the White House you were asked whether certain, or you asked a colleague rather, whether certain organizations were on a list of organizations eligible for certain tax deductions, and you referred to two of them. One was the NRA, the other was the KKK, and you referred to them as, quote, bad guy orgs, I presume an abbreviation for organizations. So if you're presented a case involving, for example, the NRA, would you consider the NRA to be a bad guy org deserving of defeat in the case?
Senator Kyl, I'm sure that that was not my reference. The notes that you're referring to are notes on a telephone call, basically me jotting down things that were said to me, and I don't remember that conversation at all, but just the way I write telephone notes is not to quote myself.
Okay, so your belief is that you were quoting someone else when you wrote bad
Or
guy
paraphrasing
orgs.
Somebody else, but it
Those
was
weren't
not, it was just telephone notes.
And it wasn't your terminology, it was somebody else's.
Or, as I said, or a paraphrase, but it was, you know, the way I write telephone notes is just to write down what I'm hearing.
You wouldn't, in any event, put the NRA in the same category as the KKK,
It would be a ludicrous comparison.
Thank you. In another case, in recommending the grant, this is United States versus Kosminski, in recommending the grant of cert, you noted that the Solicitor General was, quote, for once on the side of the angels. Now, obviously, it's not whose side you're on that makes the
I
difference.
hope that's not my good friend Charles Fried.
Indeed it was. It is. It is and was. How do you define who's on the side of the angels?
I have not seen that memo, Senator Kyl, but I'm sure it was saying essentially the same thing, which was the Solicitor General had the better of the legal arguments, as Justice Marshall would understand those legal arguments.
You said.
I'm sorry, Charles.
Well, have in your time as SG, have you made any litigation decisions based on an assessment of which position was the side of the angels?
I've tried very hard, Senator Kyl, to take the cases and to make the decisions that are in the interests of my client, which is the United States government.
And it wouldn't be appropriate as a member of the Supreme Court to decide cases based on that either.
Senator Kyl, a Supreme Court justice needs to decide cases on his or her best understanding of the law.
Let me ask you, in the minutes that remain here, about one of the decisions that you made in connection with a request by the court for the SG's opinion. The case is Chamber of Commerce versus Candelaria. This is an Arizona decision. You'll recall it involved a 2006 law that then Governor of Arizona, Janet Napolitano, had signed, and which requires all employers doing business in Arizona to participate in the federal government's E-Verify system that verifies Social Security status, and also provides that employers who knowingly employ illegal aliens can be stripped of their business licenses. Several groups challenged the Arizona law, saying it was preempted by federal immigration law, but the Federal District Court in Arizona and a unanimous Ninth Circuit panel upheld the law. The opponents of the law asked the Supreme Court to take the case and strike down the Arizona law, and last November, the Supreme Court asked you, as Solicitor General, for the government's views. Ultimately, you decided to ask the Supreme Court to take the case and strike down the employer sanctions that are critical to making the Arizona law work. You and I talked about this case, and you're familiar with it to discuss it. You did not argue that the court should take it because there was a split in the circuits.
That's correct, Senator.
Or that there had been an unconstitutional application of the law in any way.
Senator Kyl, I think what we argued in the petition was that the Arizona statute, or at least this part of it, was preempted by Congress, and therefore that the decision below was wrong, and that the reason for the court to take the case was not only that it was wrong because the Arizona statute was statutorily preempted, but but also because this was an important question. It's one of the category of cases where...
It's that third category you said a moment ago that there aren't very many, but where they are, they're important.
That's right.
And
Lots of states are passing these kinds of laws, and that guidance from the Supreme Court would be appropriate as to what kinds of legislation.
The Supreme Court isn't in the business of giving guidance, though, is it?
Well, I think for the Supreme Court to set down its view of what the federal statute preempts would be very helpful to state legislatures.
Sure, but, I mean, the court turns down hundreds of cases, and I'm sure its ruling in each case would be helpful. As I recorded your comment earlier this morning, in that third category, you said that it would have to be a strikingly significant issue for the court to take the case in that third category of an important federal question.
Senator Kyl, what we argued to the court in the Kansas area...
You said it should be a strikingly significant issue. Did you not?
I'm honestly
okay.
not sure
I got the quote
words
accurately.
I used, but if I might, Senator Kyl,
Go ahead.
What we argued to the court in Candelaria was that there was a federal statute in this case. I know that, well, there was a federal statute in this case. Our best read of that federal statute was that it preempted the licensing provision of the Arizona law. That was our best understanding of what the federal statutes did. And that because there's so much legislative activity in this area happening across this country right now, that for the Supreme Court to decide that question and to determine whether the federal statute preempted the state law was one of those moments where the issue is of real significance across the country.
So you think that made it strikingly significant?
I think that this is a significant issue, and people, I think, on both sides agree that it is a significant issue as to whether the federal statute prevents states from doing this. And this is, again, not a decision or a view as to whether these state statutes are good or bad. They might be very good. The only question is whether Congress has, by legislation, and here the legislation was in the immigration...
And here's what the federal law says. I mean, it says this is an area for the federal government, but under the federal law, states are explicitly permitted to legislate in this area, and I'm quoting the statute now, through licensing and similar laws, through licensing and similar laws. And you argued in your brief that the state's revoking of a license didn't qualify for that explicit exception to federal preemption under the federal statute, right?
Senator Kyl, what we argued in the brief was that the Arizona law did not qualify under that exception, because what that exception was meant to talk about were sort of traditional licensing laws of the kind when, you know, you license a lawyer or you license a doctor or you license a chiropractor, but not a law that essentially imposes sanctions on any employer for...
Court meant for states to be able to do exactly the kind of things that the state of Arizona did. It wasn't limited to licensing a professional. It was the denial of a license to someone who was violating the law.
Yes, we definitely took a different position, Senator Kyl, and the reason we did is this statute clearly would prevent a state from saying anybody who hires an undocumented or illegal alien would be fined $25. The statute clearly prevents a state from saying that, from imposing a penalty on an employer who hires an illegal alien. And if the statute clearly prevents a state from imposing a penalty like that, then surely the statute also prevents a state from imposing a penalty, which is the withdrawal of any ability to...
That's the argument that you make, but surely the federal government could impose a fine, but the federal government doesn't get into the licensing of businesses. That's a state activity. So I could argue just as easily, and I'm sure the court will consider the argument that, of course, that's the kind of thing that states can do. And so just as a state could grant a license, it could also take a license away if a business violated the law. We'll talk a little bit more about this, I guess, in the second round. But the reason that I raise this is that my guess is, and I would ask you whether you agree, that without the SG having taken the position that you did, that it's much less likely that the court would have taken the case. Would you agree with that?
You know, I don't know that, Senator Kyl. Sometimes they listen to us and sometimes they don't. Sometimes we tell them in no uncertain terms, this is a terrible case to take, and they take it anyway.
The stats are 80%, so that's a pretty good percentage when you ask them to take a case, and they do.
Was this a case where the Supreme Court asked the Solicitor General to file a brief?
Yes.
This is a case where this, and those are the 80% statistic, I think, is the statistic when the government files its own cert petition. I think that we do much less well with the court when we answer the court's requests for, you know, our advice on whether.
We'll when we have the next round, I'll have the exact statistic on that.
I hope we do well. I hope.
I think you do very well.
Okay.
Okay.
Thank you.
Senator Feingold, and then when Senator Feingold finishes, we will break, and I would reiterate the senators and. Senator Kyl, you're in the leadership. You probably know this, but apparently the vote is at 2:15. I will vote at the desk and come back, and I will recognize the next person in line to be on the Republican side. Senator Feingold.